Well, good afternoon to you, Nzinga, and the viewers at home. I'm coming to you live from the Gauteng High Court in Johannesburg, where the President's lawyers have just concluded their arguments in the application to bring this private prosecution bid by the former President Jacob Zuma to an end. President Cyril Ramaphosa is seeking a final interdict. He's also seeking a review of those summons as well as the nollie prosecution certificates, hoping that or praying rather, that the court will declare that nollie prosecution certificate unconstitutional and invalid. Just a quick background so that we can understand the arguments that were made by Advocate Nwako Maneche, SC, in the court this morning. This issue essentially, Nzinga, centers around this common theme of the alleged disclosure of the former president's health records in his corruption trial at the KZN division of the High Court, which sits in Pietermaritzburg. So essentially what has taken place there is that the former president in August of 2022, through his lawyers, wrote a letter to the president in his capacity as the president, and only according to the powers that he would enjoy as the president, asking him to submit a commission of inquiry into the alleged conduct of a senior prosecutor in that alleged breach of his health records, which he alleges were disclosed unlawfully during that corruption trial. The president responds in the same month, in August of 2022, to say that he takes this matter quite seriously. As you've heard in court, that specific letter was read out again to the court. He takes this matter quite seriously. He's referring it to the Minister of Justice to refer to the LPC. So it's not quite the remedy that the former president wanted. And what we understand, that because of the delay in seeking a conclusion to that alleged breach, the former president then attempted to launch this private prosecution bid against the president, alleging that he was an accessory after the fact because he allegedly failed to act on this breach, which the former president argues compromised the NPA and by extension the criminal justice system as a whole. So that is at the core the issue that we're dealing with, Nzinga. However, the lawyers for the president have come to the court saying that although he was approached in his capacity as the president, he also enjoys constitutional rights as an individual. And he's stating that as an individual as well, he has a right to defend his constitutional rights, and in that office together as well, he has an obligation to protect the Constitution and advance its rights. And on that basis alone, he's arguing that he has a right to not be hauled before the criminal dock on a process that he argues was constitutionally flawed. That's when we move to the nollie prosecution certificates. That is the second certificate that was used that almost, if I could put it that way, broadened the scope, or that is at least the interpretation of that nollie prosecution certificate that was issued, where the DPP stated that they decline to prosecute, quote unquote, anybody in this matter. So Maneche has argued before the courts that you cannot honestly look at this nollie prosecution certificate and look at it as a literal interpretation, because the supplementary affidavit that was submitted to the KZN High Court in Pietermaritzburg for the corruption trial regarding this very issue of the alleged disclosure of the former president's health records, it mentioned the president, the Minister of Justice, the LPC, the judges, etc. If you look at that supplementary affidavit, or rather listen back to Maneche, and when he reads out that supplementary affidavit, what the former president was actually articulating in that section where the president was named, he was articulating that the president was currently investigating the alleged breach. So Maneche is actually arguing before the court that one cannot conclude that when this supplementary affidavit was submitted, that anyone would interpret it, or former President Jacob Zuma rather meant that the president was a suspect in the matter. Rather, he looked at him as someone who was advancing the cause or investigating the issue that he has raised a concern with. So those are the closing arguments of Maneche with regards to nollie prosecution certificates. Then if we move to the jurisdiction, there's been this issue regarding the parallel hearings that we're seeing in this matter, Nzinga. There's a criminal court and the civil court. Now we know that despite the interim court order that was ordered in January by the civil court earlier this year, that the president still did go to the criminal court to ensure that the matter was still enrolled. So on the 28th of May, or 27th rather, I stand to be corrected, that matter is still going to return to the criminal court pending the outcome of Part B of this application. But what the former president is advancing is that the current president didn't have to come to the civil courts to solve this matter, that this matter could have been easily defended in the criminal courts. And we've heard Judge Madiba raising that concern of the distinction between the two courts and recognizing that it shouldn't be overly simplified. And I think that the lawyers have conceded that yes, they serve very different roles, but it doesn't preclude the president from coming to the civil courts if he feels that his fundamental rights have been infringed on by being hauled before the criminal dock. So that sums up some of the key arguments that were made by Maneja here in the civil courts at the Gauteng High Court in Johannesburg. After the lunch adjournment, we do expect a response from former President Jacob Zuma, which will be submitted by Advocate Dali Mpofu in the court. Over to you in studio.